Good morning, my dear friends and my viewers. Today, I'm going to make a video on punishments under IPC, Indian Penal Code 1860. Now, Section 53 to 75 of the Indian Penal Code deals with this scheme of punishments. Now, Section 53 of the Indian Penal Code prescribes five kinds of punishment. Now, first of all, let us discuss what is punishment. Punishment is a process by which the state inflicts some pain to the persons or property of a person who is found guilty of a crime. Okay? In other words, we can say punishment is a sanction imposed on an accused for the infringement of the established rules. Now, what are the object of the punishment? The object of the punishment is to protect the society from mischievous and undesirable elements who are deterring potential offenders, and by preventing the actual offender from committing further offenses, and by reforming and turning them into law abiding citizens. Now, Section 53 of the Indian Penal Codes prescribe five kinds of punishment, such as death, imprisonment for life, and imprisonment which has two kinds of description, that is rigorous, it means a hard labor, and a simple imprisonment, and the another one is forfeiture of property and fine. So now let's discuss one by one. The death penalty or a capital punishment is it's a kind of most serious nature of punishment. Some countries abolished it. A death sentence may be awarded under the Indian Penal Code if a criminal is waging or attempting to wage war or abetting to waging of war against the government of India, which is described in section 121 of the Indian Penal Code. Now, abatement of mutiny. So, if a person is committing an abatement, if a mutiny is committed, then it is defined in section 132 of the IPC. Now, giving or fabricating false evidence upon which an innocent person suffers death. So, it is also defined in section 194. The death penalty is awarded in such conditions. Murder, if you talk about murder, which is defined in section 302 of the IPC. Now, abatement of suicide of a minor or an insane or an intoxicated person, which is defined in section 305 of the IPC. Now, attempt to murder by a person under sentence of imprisonment for life if hurt is caused. So, it is defined in section 307 of the IPC. Then, kidnapping for ransom, which is defined in section 364A of the Indian Penal Code. And the next one is dacoity with murder, which is defined in section 369 of the IPC. Now, the another kind of punishment, which is imprisonment for life. So, life imprisonment means a sentence of imprisonment running throughout the remaining period of a convict's natural life. That means still is death. But in practice, it's not so actually. According to section 55 of the Indian Penal Code, in every case in which a sentence of imprisonment for life shall have been passed, the appropriate government may, without the consent of the offender, commute the punishment for imprisonment of either description for a term not exceeding 14 years. So, section 57 states that in calculating fractions of the term of punishment, imprisonment for life shall be reckoned as equivalent to imprisonment for 20 years. So, there was a famous landmark case in Kem Nanavati versus State of Maharashtra, AIR 1962, Supreme Court 605. So, in this case, Honorable Supreme Court held that imprisonment for life means rigorous imprisonment for life, not a simple imprisonment. Now, such kind of imprisonments are defined in two terms like rigorous imprisonment and simple imprisonment. Rigorous imprisonment means hard labor such as cutting, digging, breaking of stones. So, according to the section 60 of the IPC, in every case in which an offender is punishable with imprisonment, which may be of either description, it shall be competent to the court which sentence such offender to direct in the sentence that such imprisonment shall be wholly rigorous or that such imprisonment shall be wholly simple, or that any part of such imprisonment shall be rigorous and the rest is simple. So the IPC prescribes imprisonment as punishment for giving or fabricating false evidence for with intent to procure conviction of a capital offense, which is mentioned in section 194 of the Indian Penal Code. Now, house trespass in order to commit offense punishable with death, which is mentioned in section 449 of the Indian Penal Code. Now, if we talk about the simple imprisonment is imposed for small offenses like wrongful restraint, defamation, and in case of simple imprisonment, the convict will not be forced to do any hard manual labor. Okay, so there are some offenses which are punishable with simple imprisonment, such as like refusing to take an oath under section 178 of the IPC, then defamation, which is defined in section 500 of the IPC, wrongful restraint, and misconduct by the drunken person, which is defined in section 510. So now the next type of punishment which we will talk about is solitary confinement. Now, what is solitary confinement? It means keeping a prisoner through isolated from any kind of contact with the outside. A harsh and hardened convict may be confined in a separate cell to correct his conduct. Court can award his punishment only when the offense is punishable with rigorous imprisonment. And solitary confinement may be imposed subject to the matter in following restrictions, such as solitary confinement should not exceed 3 months of the substantive term of imprisonment. Then it cannot be awarded where imprisonment is not a part of the substantive sentence. It cannot be awarded for the whole of the term of imprisonment, and it cannot be awarded where imprisonment in lieu of a fine. So according to section 74 of the IPC, in no case the sentence of solitary confinement will be awarded more than 14 days at a time. So it must be imposed at an interval, not regularly. Now the another kind of punishment is forfeiture of punishment, which is a fourth kind of punishment in the IPC. So forfeiture of property means taking away the property of the criminal by the state. So forfeiture of property is now abolished except in few cases, few offenses like committing depredation on territories of power at peace with the government of India, which is defined in section 126 of the IPC, then receiving property taken by war or depredation mentioned in section 125 and 126 of the IPC. So these are these conditions for the forfeiture of the property, and the last one is fine. So court may impose fine as sole imprisonment or alternative, or it may be imposed in addition to the imprisonment. In IPC 1860, it prescribes fine along with the imprisonment in respect of certain offenses. In default of fine, imprisonment may be imposed. If the criminal is failed to impose the fine, then he will be given the imprisonment. Okay, so if you like my video, please like and subscribe to my channel, so it will motivate me to make more and more videos. Thank you, friends.